Hello, this is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2020 Harlan Institute Ashbrook Virtual Supreme Court Competition. Today, we are arguing the case of Torres versus Madrid. I'm honored to be joined by my fellow colleagues, Justice Sparks and Justice Brown, who will be judging today's match. Today, we have two teams. Team 7872 will be the petitioners. We have Senou and Ayaan. Please say hello.
Hello, Your Honor.
Hello, Your Honor.
And then we have team 7852, the respondents. We have Anita and Kashish. Please say hello.
Hello.
Hello, Your Honor.
And today we're going to be arguing the case of Torres against Madrid. All right, petitioners, whenever you're ready, you can begin. You have 10 minutes.
Mr. Chief Justice, and may it please the court. On July 15, 2014, petitioner Roxanne Torres had parked her car at an apartment complex. Respondents approached an attempt to open the driver's side door of Mrs. Torres' vehicle while she was seated inside. Believing respondents were armed carjackers, Ms. Torres drove forward to escape. As the car began to move, respondents opened fire on Ms. Torres, trying to stop her. Two of the bullets entered her back and temporarily paralyzed her left arm. Ms. Torres sued respondents for violating by shooting her in the back, her Fourth Amendment right to be free from unreasonable seizures. The district court granted summary judgment for respondents on the basis that Ms. Torres was never seized and could not bring an excessive force suit under the Fourth Amendment. The 10th Circuit affirmed the district court decision. Neither court discussed the question of reasonableness.
Using the court's past precedent to guide its analysis, this court will find that an unsuccessful attempt to detain a suspect by use of physical force is a seizure within the meaning of the Fourth Amendment. The requirements for a physical force seizure can be explained through three cases: Terry v. Ohio, Brower v. County of Inyo, and California v. Hodari v. The court recognized in Terry that a seizure occurs only when an officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen. This ruling established two categories of seizures: physical force seizures and show of authority seizures. As outlined by the court's ruling in Brower, to constitute a physical force seizure, the physical force must be intentionally applied to the suspect. And lastly, Hodari D, using common law from the time of the founding, found that the clear line between a physical force seizure and a show of authority seizure was the mere grasping or application of physical force with lawful authority.
Hey, Counselor, I'm sorry, Counselor, if I could interject for a minute. You said we should look to the common law. What is the leading historical source, the best piece of historical evidence that supports your definition of a seizure?
Of course, Your Honor. Currently, our best historical source would be probably Jenner v. Sparks, which is a case from the English common law around the same time of the founding. In that case, of course, there was a debtor who was almost seized by a bailiff, but the bailiff did not touch him. So the English court ruled that no seizure occurred.
Well, were there police officers back then? I mean, is this a good analogy to the sort of law enforcement we have today? Is it the same type of relationship?
Your Honor, yes, we believe it is the same type of relationship, particularly because it's less about the structure of the police force at the time. It's more about the definition of what a seizure is. So when the founders used the word seizure, they were implicating that common law of arrest that occurred around that time of the founding. So even though we have a different police force today, it's the definition of seizure should be understood as it was at the time of the founding.
And so
you agree that that is a civil law arrest. It's not criminal.
Yes.
Okay.
Yes, Your Honor.
Is force the same as contact? When you talk about physical force, as opposed to just mere contact, are those two things the same for the purposes of your argument?
Yes, Your Honor. Both physical contact and force are the same for the purposes of our argument. We look to common law as well as Hodari to show that the mere grasping or application of physical force onto the arrestee, whether it was sufficient or not in subduing that arrestee, is sufficient for a seizure to occur. And that could occur through a variety of ways, whether it be a baton hit, a tackle to the ground, or a gunshot, like in this case before us today.
Now, let's talk about Hodari for a minute, because this case sort of troubles me since Hodari did not submit to authority. We understand that, and neither did Torres. He fled, and they didn't get control of him until much later in the process, but they're focusing on that earlier segment where he's carrying that piece of cocaine, apparently. So there, in the court rules, there's no seizure here. There's no seizure. So how come you're using a case that rules there's no seizure when you're trying to establish that there is a seizure?
Of course, Your Honor. In Hodari, the part of Hodari that we're using is the part where the court in that decision used common law to distinguish between a physical force seizure and a show of authority seizure. So it was critical to that decision that the court outlined that the second that the police officer touched Hodari later on in the process, that was when the seizure actually started. And that led the court to conclude that everything that happened prior, when he threw the rock of crack cocaine, that was not a seizure, that he had not yet been seized. And so that common law definition of arrest that the court used was essential to that part. And then the rest of the decision where the court outlines that the mere whether or not the suspect was subdued, it's still a seizure. That part of the decision, we will say it's not essential to that decision, but the logic put forth in that decision, using the whether or not it was successful or not, that was grounded in common law. And so the court should continue to take that path of analysis to remain consistent.
So it's not, you're admitting that the holding there doesn't help you. It's the analysis that the court provides. But isn't it fair to say that that's just dicta? In other words, they pose a hypothetical, but that hypothetical is not the facts of that case.
Yes, Your Honor. To qualify our statement, in Hodari D, we understand the distinction between a physical force seizure and a show of authority seizure. And that's distinction, that separation between the two types of seizure that was initially recognized in Terry v. Ohio is critical to understanding the court's case today. And in Hodari D, the case that Your Honor mentions, Hodari the child fled away from a police officer who was exhibiting a clear sign of show of authority. Hodari fled the scene, and so he did not submit to that show of authority. And so in that case, a show of authority seizure did not occur. However, we aren't using that as applicable to this case. But what we must understand is that the distinction between a show of authority and a physical force seizure is the presence or application of physical force in order to restrain the person's movement. So that moment where the officer tackled Hodari later on, that is when a physical force component was added into the analysis of Hodari D. And in that moment, that mere application or physical force, whether or not it was successful in subduing the arrestee, that moment is what we are using in this court today. Because in today's court, Petitioner Roxanne Torres had her Fourth Amendment violations, had her Fourth Amendment protections violated because she was shot twice in the back in the torso, a clear and explicit form of physical force.
So, but Counselor, was she actually seized? Because as I read the facts, she was able to travel for about 75 miles to another town. I mean, doesn't that suggest that she wasn't seized, that she was able to keep going? That it's granted, not everyone who's shot can keep going, but she kept going.
Mm-hmm. Yes, yes, Your Honor. So for that clarification, we also look to Whitehead v. Keys, which is a court case that's also referred to in Hodari, where they say that a seizure is a single act, not a continuous fact. So under our analysis, the seizure occurred when the bullets pierced Petitioner's body in that moment. So the fact that she fled afterwards is irrelevant because the seizure had already occurred and there's no continuing seizure, as the court also points out in Hodari.
Okay, may proceed.
In the case before the court, respondents applied physical force to Petitioner with intent to restrain her freedom of movement. The bullets they fired were an application of physical force to restrain movement because they were intended to terminate the Petitioner's ability to drive her car and because they resulted in a wound that paralyzed Petitioner's arm. Since, as the court recognized in Hodari, a seizure is a single act and not a continuous fact, a seizure by physical force occurred at the moment that the bullets pierced petitioner's body. The fact that petitioner drove away is irrelevant as the court's precedent of founding era common law, to which the respondents raised no valid counter arguments, and the fundamental intent of the Fourth Amendment, which is to protect citizens from intrusions, governmental intrusions, show that the suspect's flight does not dictate the presence or absence of a seizure. The court should follow its reasoning in Hodari in ruling that the intentional application of physical force alone constitutes a seizure, whether or not it succeeded in subduing the arrestee.
Okay, thank you, Counselor. Appreciate you finishing a little early. You can turn your cameras off and the respondents can begin. You have 15 minutes whenever you're ready. You may begin.
Mr. Chief Justice, and may it please the court, my name is Anita Ashok, and alongside my co-counsel Kashish Bastola, we will be representing the respondents in today's case. So in the case presented before us, Petitioner Roxanne Torres had an encounter with the Albuquerque Police Department on July 15th of 2014. The officers tried to converse with Torres, but resulted in her fleeing the scene, resulting in the officers withdrawing their firearms and firing their weapons. 2 of the bullets did strike Torres, but she was able to flee the apartment complex. So the question presented before the court today is whether an unsuccessful attempt to detain a suspect by the use of physical force constitutes a seizure within the meaning of the Fourth Amendment, or must this physical force be successful in detaining the suspect in order to constitute a seizure? And from its inception, the United States Constitution has recognized that the Fourth Amendment term seizure means intentionally taking custody, possession, or control over a person, meaning that a seizure under the court's interpretation requires a restraint to one's freedom of movement. So the 2 main points that we would like to cover today when understanding the answer to this question is that 1, Roxanne Torres maintained her freedom of movement, meaning that she was able to flee the apartment complex and travel over 75 miles after her encounter with the police. And 2, Hodari D and its common law precedents should not have any bearing on this case, as the facts of Hodari D and the facts of this case presented are vary greatly, and common law derived from a time period which is not applicable to the case today.
Your Honor, we'd like to begin by asking the court to consider the purpose of common law in today's case, specifically in the context of Hodari D, which should have no bearing on this case, as my co-counsel just mentioned. Hodari D, again, is factually removed from the events of the issue at hand today, and this is mostly due to the lack of firearms or other militarized weapons, which was completely absent in Hodari D. Because of this absence of firearms or militarized weapons in Hodari D, it's easier for the court to use common law in reference to specifically Hodari D. However, the common law definition of arrest is too narrow and limited to apply to all seizure cases.
If I could jump in for a minute. So what is your leading common law source of authority that supports your interpretation of a seizure?
Yes, Your Honor. As respondents, we look to an appeal from 1825, the Josefa Segunda, which fits in within the founding generation. And though it does not, it's not in the context of a seizure of a person's, it's in the seizure of ships in the African slave trade, it still does apply to this context as it shows an example of militarized conflict with in which a vehicle is armed in the founding generation. So specifically in the Josefa Segunda, it deals with a ship which was armed, and it lays out the criteria to seize a ship.
Was that a civil case or a criminal case?
I believe that was a civil case, Your Honor, but I'm not completely sure on that.
Okay, well, I think my colleague Justice Sparks asked a similar question earlier. Can we extend cases about civil law to criminal law? Are there any differences?
I believe that it is applicable to this. I believe that it does transfer. I think that the respondents use the Josefa Segunda, that appeal, as to show how even the common law definition of an arrest from the founding generation, or the common law definition of a seizure from the founding generation, still does extend to the seizure which did not occur in the attempted seizure of this case. However, regardless of what the common law definition of arrest is, we do believe that it does not fit within the context of the events in this case, especially as petitioner says that the structure of policing and the field of policing doesn't matter. However, respondents do disagree with that. And we do believe that, there was no bureaucratic entity for police departments in the founding generation, and the role of law enforcement in our communities has drastically shifted from the founding generation, and it's shifted away from private citizens making arrests and constabularies to bureaucratic entities, as I just said.
Earlier you said something about her, that her liberty really wasn't restrained because she was able to drive off and commandeer another car and drive 75 miles to a hospital. But I mean, after all, one of these shots paralyzed her one arm. So she now, before this shooting occurred, she had the use of two limbs, and now she has only the use of one of those limbs. I mean, she's a hardy soul because she carries on anyway. However, her liberty certainly has been restricted, it seems to me, by the action of the police, and they also have, it's also changed her plan of action. She was headed for home, and now she's headed for some other, she decided she has to have another vehicle, and then she goes to the hospital to get treatment. And so the police have altered her liberty and plan of action, and also affected one of her limbs. So how is it that cannot be a seizure of her and a restriction of her liberty?
Your Honor, as respondents, we're not trying to downplay Ms. Torres's injuries. What we're trying to say is that despite those injuries, despite the fact that her left arm might have been paralyzed, it was the fact that she was able to transport herself over 75 miles to a hospital. It's the fact that she was able to escape within the grasp of the officers and take herself out of the situation. That's what we're emphasizing.
Well, suppose she had gone, she'd been shot. She jumps out of the car, runs, and goes for 10 blocks, and then falls.
Your Honor, in that case, we would say that she was seized because 10 blocks, I would say, is a reasonable distance for police officers who, keep in mind, were on foot. They were not in their vehicles like Ms. Torres was. So even 10 blocks, the fact that after 10 blocks, her movement was terminated, her freedom of movement was terminated, that amount of time and that distance is reasonable for the police officers to then take her into custody and, take her into the custody of the authority. Counselor,
in your mind, is there a difference between an arrest and a seizure, or are those terms the same thing?
So Your Honor, what we're saying is that an arrest and a seizure are very similar. I wouldn't say that they're completely the same, because what we're saying is a seizure takes place when the suspect's freedom of movement is terminated, which does not necessarily constitute an arrest.
So you can be seized without being arrested. Is that your position?
Yes, Your Honor.
Well, the sort of common law cases we're talking about, were those arrest cases or seizure cases?
Go ahead.
Your Honor, I actually would like to go back to what Petitioner cited with Jenner v. Sparks. We, as respondents, we believe that this case actually did draw a clear line between an arrest and a seizure, even under common law principles and the common law definition of an arrest, since we believe that Sparks maintained a freedom of movement away from the bailiff. And because of that, there was no arrest, and there in turn was no seizure, which we do believe carries on to this case at hand as well.
By the way, that was not a relative of mine. That's Sparks. You spent a lot of time in your brief on qualified immunity. Do you think that issue should be taken up by the court at this point? I mean, that immunity issue is something that would arise in the 1983 action if it went on, but do you think that's important for us to consider at this point?
Your Honor, what we're saying is that a seizure did not take place, but the idea of qualified immunity takes into account reasonableness. And so we believe that if there was a seizure, then the officers would be protected by qualified immunity. But what we are arguing is that there was no seizure. So no, in this case, qualified immunity would not be something that's taken into account for this decision.
So in this case, the police were clearly intending to seize her, and they took drastic measures to try and seize her. Why is that intention to seize the petitioner not enough to be a seizure?
Your Honor, there was a show of authority. So the incident of this case started with a show of authority on behalf of respondents Madrid and Williamson. And we understand that, according to common law, the common law definition of an arrest, this was a seizure during the founding generation, as there was physical force. And however, this obviously, as petitioner was able to transport herself very far from respondents, very far from the custody or control of respondents, there was no seizure in this case, regardless of any injury, regardless of any paralyzed arm, there was no injury. And we, instead of relying on common law as respondents, we shift the court's attention to the Mendenhall test, which does lay out and is affirmed by Brooks v. Gainesville, which was decided by the 10th Circuit Court, as well as Brower, which again did affirm the Mendenhall test and is a more recent example to support that the show of authority that was displayed by respondents in this case did not merely constitute a seizure under the Fourth Amendment's jurisprudence.
Are there any protections in the Fourth Amendment for unreasonable attempted seizures?
Your Honor, according to County of Sacramento versus Lewis, an attempted seizure does not fall within the scope or coverage of the Fourth Amendment seizure clause. An attempted seizure, especially under a common law definition of an arrest, does not apply there either. We do ask, again, the court to refer to the Mendenhall test when referring to this attempted seizure and this unsuccessful seizure.
If I may add, if ruling in favor of the petitioner blurs the line between an attempted seizure and a true successful seizure, saying that a seizure takes place with the mere grasping of physical force does not allow for any difference between an attempted seizure and a successful seizure. But in what we're arguing, saying that in order for a seizure to be constituted, the suspect their movement must be completely terminated, and they must be taken into the authority of the custody of the authority, meaning that we are drawing a clear distinction between an attempted seizure and a successful seizure.
Thank you.
Do you think that the question of the consequences of this decision should be considered by the court either way? That is, should they be thinking about the effect this has on Tory's 1983 action? Should they be considering that? Or should they be considering the effect that this has on police enforcement? Or should they simply be looking at the language of the cases and the legislation, if there is the Constitution? What do you think?
Yes, Your Honor. As respondents, we do believe that the language and the fact, each individual case should be considered when viewing and when considering how a specific case fits in to the definition of a common law arrest. And we also do think that a common law arrest in this specific situation is not applicable. And again, referring back to petitioner's Section 1983 claim, we do believe that there was no seizure, therefore there should be no excessive force claim on behalf of petitioner. And we do hope that the ruling of this court will influence that attempt for petitioner to pursue a Section 1983 claim.
Yes, and we also believe that it is important to consider the effects of the ruling of this case, because ruling in favor of the petitioner would hinder the ability of the police to successfully fulfill their duties without being sued on excessive force claims or unreasonable seizure claims. So in ruling in favor of the respondents, it draws a clear line between a seizure, an unreasonable seizure, and an attempted seizure. We define seizure as the termination of movement and when the suspect is taken into full custody.
Well, apparently there was a good deal of confusion here because the circuits all differed on this. So there certainly was need for some clarification.
And counsel, you have 30 seconds left. Do you want to wrap up your conclusion?
Yes, we'd like to again point out that the two main factors to consider are her maintained freedom of movement and the fact that this case and cases such as Hodari D are vastly different. And ruling in favor of the respondents today would allow the police force to successfully fulfill their duties of protecting and serving the people.
Okay, excellent. Thank you so much for the time to spare. All right, petitioners, please bring your camera back on and you have 5 minutes for rebuttal.
Yes, Your Honor. What respondents fail to argue is they, one, say that Torres maintained freedom of movement, and two, that Hodari's facts vary greatly and that common law is not applicable. Going to the first point that respondents made, they said Torres maintained a freedom of movement after the gunshot. Well, we just have to look at the precedent in Hodari, which cites Whitehead v. Keyes, that a seizure is a single act, not a continuous fact. So that moment in which the bullet wounded Ms. Torres is the moment in which a seizure occurred. Anything after that, there was no seizure, but that specific time interval where physical force was used in order to intentionally restrain the person's movement, that is when a seizure occurred. And going on to their second point, that Hodari D's facts vary greatly, that common law is not applicable, we look to Wyoming v. Houghton. And Wyoming v. Houghton states that common law is the first reference when considering constitutional provisions, such as the Fourth Amendment in this case today.
I have
yes, Your Honor.
When we're talking about the word seizure, it seems like the ordinary meaning of this would involve some kind of possession or control over something. What here constitutes a seizure? I mean, if her liberty is restricted, that doesn't mean she's been seized, right? That just means that she just doesn't have as much liberty as she did before. So why, with the plain meaning of the word seizure, is there no element of actual possession by the authority or control of the authority over the person who's being seized?
Of course, Your Honor. To answer that question, of course, as my co-counsel was saying, the first step we do is, of course, look to the common law, because regardless of what our definition today of a seizure is, United States v. Underwriters Association says that we must construe the words in the Constitution to mean at least what they did at the time of the founding, and we don't want to have a narrower meaning. So in order to look at common law for that answer, we look to cases like, or not only cases, but even definitions of seizures, right? Because that's what you were talking about, Your Honor. And at the time of the founding, people like Webster or Samuel Johnson were defining seizure, the word seizure, in a way that incorporated also the common law of arrest. So that's the first link. Then the second link is the fact that at the time of the founding, the common law of arrest also included the fact that if you were just merely touched, it would be a seizure. The respondents do bring up the warrant on the charming ship Sally, that one case, to justify that common law is not applicable in this case. However, that case is separate because it's the seizure of an object. So we do agree with those respondents that the seizure of an object does require control. This is something that the court did outline already in Hodari. However, when you seize a person, it is an arrest. And that's something that the definitions at the time of the founding from Samuel Johnson, even the Massachusetts Declaration of Rights, that it's ingrained in all those founding documents. That
hold on for a minute, dear. Are you saying that because an object can't flee, that distinguishes it from a person? Is that what you're?
Not necessarily. I'm not saying that an object cannot flee. It's
because in Hodari itself, they referred to a ship fleeing, an inanimate object.
Yes, Your Honor. Yes. In Hodari, they did say that a ship is still fleeing, even though under attack cannot be considered to have been seized as a war prize. But however, the court does go on to say that the quintessential seizure of the person under the Fourth Amendment jurisprudence is the mere grasping or application of physical force with lawful authority. So the court in Hodari does distinguish, if you have an object, you have to seize it. But if you have a person, it activates the common law of arrest, which is the ruling in Hodari, and thus it is a seizure of a person.
Thank you.
And Your Honor, just to clarify what respondents were arguing previously, they argue that Hodari does not have bearing on this case today because Hodari, the child, did not submit to the show of authority from the police officer. But what's critical to understand is that there are two distinctions of seizure, show of authority and physical force. And in Hodari, a show of authority seizure did not occur because the child did not submit. However, that moment, which is integral to the analysis of this case, where the officer touched and tackled, occurred under the physical force requirement. If we look to Brower, the intent requirement is needed as well as a physical force in order for a seizure to occur. And so in this case today, petitioners argue that there was a seizure occurring regardless of whether subduing the arrestee occurred or not. A seizure was sufficient.
Okay, excellent. Thank you so much. Right on time.
Thank you, guys.
If everyone could just bring their cameras back on, please. That was fantastic. I truly have to commend both teams. You did so much hard work to get to this moment. I know you've done a lot of preparation, a lot of research, and look, I couldn't do this when I was in high school, not even close. I don't think I could do this in law school even. This is really super. I give credit to the students, also to your coaches who've done a really good job in teaching you this past year. I appreciate the mask on, mask off. I know that's not easy. It's just it's one more thing you guys have to think about. I think that you actually had the routine down pretty well. I think that was very effective. And I think also for Anita and Kashish, you're doing this by Zoom, where your partner's in a different place, and the handoffs I think were smooth. You listened to the judges. There was no interruption. There was no awkward silence. I think everyone responded smoothly. I think each team very effectively responded to the other team's arguments, which is hard because this is not prepared, right? You didn't know what the other guys were going to argue, and you had really good responses ready to roll, which is not easy. You fluidly went back and forth between your argument, the justice's question, and the arguments on the other side. This was spectacular. I really have only good things to say. We will give you the scores to your coaches on Monday. So you'll have your scores, not now, unfortunately. We got to score you soon, but you'll have your scores on Monday. And I encourage, if any of you have any interest in law school, I'm a law professor in Houston, Texas. You're welcome to come sit in my First Amendment class. I teach Mondays and Wednesdays at 1:30 or 2:30 Eastern. If you tell your coach, he'll get in touch with me to figure out how to do it. But I'm happy to have you sit in any time to watch. But thank you all so much. And John and Ryan, any comments you want to give to the students?
Ryan, go ahead.
Very good. Very good. It's not just that I couldn't have done this in high school, it's that I wouldn't have. I just would have been too afraid to have tried. But very good. You guys learned a lot. I can really tell that you studied very hard for this. And are any of you interested in going to law school eventually? Checking it out?
Yeah.
Yeah, what are your thoughts on that?
Yeah, I mean, I'm definitely really appreciative of this opportunity. I mean, I never even imagined that I get the opportunity to do moot court. So I definitely feel really a lot more prepared, and I'm sure I can speak for all of us, all students in this call, that we feel a little bit ahead of our peers now in terms of going to law school and competing in moot court competitions. Because this definitely is something that I want to consider doing in the future. So yeah, I really appreciate this opportunity.
Awesome.
And we'd like to say thank you to the competitors too as well. That was a really fun round, and it was really enjoyable. And also to the justices for taking your time out of your day and helping us further our legal knowledge. Both Senou and I do want to practice law school in the future, and I'm on the mock trial team, and this competition here has really increased my knowledge of how to argue in front of a Supreme Court. And so I just really like to say thank you to you guys and the opposing competitors, because you guys were phenomenal.
Thank you. You too.
Wonderful.
I hope you will consider law, and it's a lot of fun either teaching or practicing, as all represented here by the various judges. And it's a worthwhile and much needed to have clarity of thought about these legal issues today. And we hope you'll consider that. And I agree with Josh. I can't remember what I was doing in high school, but probably I shouldn't mention it here. But it wasn't doing all this kind of stuff. And this was a very complicated case. I mean, it was a complex case. It wasn't an easy dunk. And you worked hard on it. Thank you very much.
All right. Any other questions you guys want to ask us while we have us here? Happy to. Any questions in your mind about the competition or anything in general?
So the next level would be the Elite 8 round.
We're leaning towards a Final Four, although we're not certain. I'll be honest, we received more submissions this year than we've ever gotten before, and we're still figuring out how to manage them. So we're here basically for 6 hours today, 6 hours tomorrow, doing nothing but rounds. And I think after this, we'll tell your coaches what the next step is. But we're probably going to advance to top 2 petitioners, top 2 respondent. You guys made it to the top, basically, 24 teams, which is really impressive. We'll probably advance maybe 4 more. That's our prediction. All right, everyone. Thank you all so much. Have a wonderful day. If the students can leave the room, and the judges can confirm your grades. Thank you so much.
Thank you.
Thank you so
Have a
much.
good day. Thank
Great
you,
day.
guys.
Everybody.
Thank you.
Bye.
All right, I'm turning the record.